Is Ken Ross. I am the webinar coordinator for SPSP for this year, as I have in the past. And I want to welcome you all to the first webinar for 2024. As in the past, Sedgwick Brand Protection has allowed us to have them sponsor these webinars all year. And we thank Sedgwick and appreciate their cooperation and support. Before we get started, just a couple of quick things. One is that there'll be an announcement that goes out tomorrow concerning February's webinar, which will be on retailer manufacturer issues, and we've got a really good panel on that. So look for that. But today's topic is going to be an update on Canadian product safety issues, especially Health Canada. And this is something we don't normally talk about, but we should, because most manufacturers, retailers are in both the US and Canada, and we have multiple responsibilities to different agencies, and they're not exactly the same. They do different things, and some are more rigorous than others. And so I thought we'd have two product safety lawyers, experts in Canadian product safety issues, to talk to us today. They are Lindsay Lorimer and Rachel Cooper, and both are partners at the McMillan law firm in Toronto. And the slides, as you'll see, are very detailed, but I don't panic. I want you to know that we're posting the slides, and we'll post other reference material, possibly from the Health Canada website, on our website in the webinar archive. One, so that others at your company can look at the slides and hear the presentation. There'll also be a link to the recording, which this is being recorded, and also be able to see that material. So we encourage you to pay attention. Don't worry about scribbling too many notes, and you'll have the slides and the reference material later to refer to. So with that, I want to turn it over to Lindsay. I think you're starting, Lindsay, correct?
Correct. Thanks, Ken, very much. Very glad to be here. Thank you all for attending. So wanted to talk about something that really isn't talked about a lot first, and that is one of the mechanisms by which Health Canada regulates products in Canada. There are various regulations, as you're aware, and a number of regulated products under the Canada Consumer Product Safety Act. But Health Canada also uses general prohibitions to regulate products which they feel are a public safety issue or are potentially a danger to human health and safety. And so the Act actually prohibits any manufacturer, importer, retailer from selling products that are a danger to human health and safety. That is not actually a defined term under the Act, unfortunately. We all wish it was. And Health Canada has used that danger to human health and safety to regulate a number of items. And originally, Health Canada would do this on their own initiative without consulting industry or involving industry to find out what standards or how they should properly be assessing specific products before they made a determination on whether that product actually fit into a category that they should be looking at and looking to perhaps ISO standards or ASTM standards as being mandatory as it relates to those product groups. Health Canada has taken a different strategy recently, and they're looking towards more consultation and discussion with industry groups on how they might want to regulate these products. These are a few products that they have identified as being of specific concern. You'll see them there. There's portable generators or portable heaters. There's phone chargers or smart chargers, night lights, laundry pods, vaping pens, which is under the Food and Drug Act. And you also have barbecue brushes. There's baby pacifiers and a number of other products, including button batteries and toys with lasers. And these products have been assessed, this table 1, have been assessed by Health Canada and are currently being scrutinized. So they are intending to consult with industry about what standards they should be looking to as being mandatory. Now, when I say mandatory, I mean that Health Canada will have an expectation that your products, if they fit into one of these categories, meet one of the international or standards that have been set by voluntary industry groups. So it could be ASTM, they're willing to work with industry. It could be ISO, but you'll need to demonstrate that you've had a risk assessment done on the product, you've looked at the safety issues associated with the use of that product, and that your product does in fact meet one of those standards before they can be sold in Canada. There is a prohibition list that's open for comment. None are currently open for comment. This is a live link, and if you need us to send it to you after this presentation, we're happy to do so. But there is a web page where Health Canada will update industry on new products that they have added. And then there are certain products, some of which are addressed in the US as well. For example, tip overs on furniture, that they have used the general prohibition rather than waiting for our legislature to actually adopt legislation specific to those product categories. So you'll have ski helmets, you'll have chargers, you'll have infant wear with drawstrings, you'll have high chairs, small little magnets and lasers. And Health Canada has actually nicely put out the standards that would apply for these products on their website, and happy again to provide that at a later time. But it will tell you that there are a variety of standards that they look to. As long as you meet one of the standards or you have a rational justification as to that you're addressing this associated risk with that product, Health Canada will likely find that sufficient. But if you have no risk assessment done and you can't demonstrate that you meet that voluntary standard, expect that Health Canada would want you to actually take corrective action as it relates to the products, despite the fact that there's not a specific regulation under the CCPSA addressing those specific products. So that's just a little side view into how Health Canada is looking beyond products that might be new or that they don't want to wait for the legislature to create their own standards, and they want to move quickly. Another thing that's being looked at is micromobility products, which is something I know that the US is looking to as well. But consider these general prohibitions when looking to compliance issues in Canada and not just the specific regulations that exist under the CCPSA. And with that, I'm going to turn it over to Rachel. As Ken said, standards in Canada and the US for reporting are different. I'm sure you're quite aware of them, but you really need to consider, if you're taking action in the US, what you need to do in Canada. So I'm going to pass that over to Rachel, and she's going to speak about the next slide.
Thanks, Lindsay, and hi, everyone. Happy to be here. So in general, Health Canada expects more reporting than the CPSC does in the US. The default should be over-reporting, but the likelihood of an action being required in Canada is lower. So while a reportable incident in Canada is not necessarily reportable in the US, something that triggers a 15B in the US is likely reportable in Canada. So typically, if you're reporting in the US, you need to be reporting in Canada as well. But as we'll get into, the triggers for reporting in Canada, it's a much lower threshold. Moving to the next slide. So we have the decision as to whether or not to report an incident. And it's important to remember, obviously, that this scheme that we're talking about here, this regulatory regime, only affects consumer products. But whether something is a consumer product is an open question. If the product, including its components, parts, or accessories, could be obtained by an individual and used by an individual for non-commercial purposes, even if it's intended to be a commercial product, if it could be obtained by an individual, it counts as a consumer product. So if you have an incident that is reportable and there's a way for it to be considered a consumer product, you're going to need to report that to Health Canada. The next slide. When do you become aware of an incident? So first you need to determine whether an event is related to a consumer product that you manufacture, import, or sell into Canada. And you need to be determining whether the event is an incident. And we'll get into the second one in a second. I already talked a little bit about the first, that if a consumer can get their hands on it, it's probably a consumer product. Once you become aware of that incident, then your timelines start to run, and they're pretty quick in Canada. The information, sorry, go ahead. The information about an incident may come directly from consumers. They have a way to report straight to Health Canada. It can come through, all of the ways that you can get it in the US, right? It can come through consumer reports, phone calls to a telephone line. It can come from a lawsuit itself. There's also sources such as like other government bodies or standard bodies. If you have like an electrical safety authority, for example, they can report. And Health Canada just opened up the possibility for fire departments to report. And this means that now we're getting reports from fire marshals who aren't necessarily trained in product safety, claiming that products caused a fire. So then we have to think about, has there been an incident? And again, this is a very low threshold in Canada. An incident is an occurrence in Canada or elsewhere. And that means that if there's an incident in the US that would be reportable here in Canada, that's reportable in Canada if the product is sold in Canada. An incident could be a defect or characteristic that's known in a product, or it can be product information that's incorrect or insufficient, or may reasonably have been expected to result in death or serious adverse effects on health. It also includes a recall initiated anywhere in the world for health or safety reasons, and it can include normal or foreseeable use or misuse. Next. Okay, so then we get down into what's a serious health risk or injury. And we've listed some of these here. I don't think any of them are that surprising. Burns, broken bones, bleeding, internal bleeding, poisoning, anaphylaxis, loss of consciousness, convulsions, threats to breathing, loss of sight or hearing. I'm going to pass it over to Lindsay now. Oh, you're muted.
Thank you. A 2020 problem that continues to today, being muted. So one of the issues here is in Canada, we require global reports, and that often terrifies manufacturers because it is a huge responsibility in terms of what needs to be reported, especially when near misses are reportable in Canada. And, a lot of companies apply scrutiny as to near misses in terms of when a consumer says, well, I could have choked, or my child almost suffocated, but for the intervention of the caregiver. I think you really need to look at the circumstances that with that specific incident. If it's a death or a fatality, the default is always to report globally in terms of what we counsel our clients. You would report to the US. And if you're reporting to the US, you really should be reporting to Health Canada. Prioritization by Health Canada, if it involves a person who is vulnerable, so a senior or a child, the triage level immediately is accelerated to a manager. They look at the age of the person that was involved. Is it a new or used product? If it's a newer product, they apply more scrutiny. If it's an older product that's been passed down in generations, it wouldn't necessarily escalate as quickly. They want to look at the product and history of the product and the usage of the product, whether there have been other incidents. Health Canada has been known to go online And one trigger, for example, for one client was that there was a class action lawsuit filed in California alleging issues in terms of the compliance level of a specific product. That client then had to report to Health Canada because of that filing, and the allegations that were made relative to the issues that could arise. And it was all near misses. So when you're considering, when you get a lawsuit and it alleges a personal injury or significant property damage, that would trigger a reporting obligation provided that you sell that product in Canada. And that's a consideration you need to make when filing. It doesn't mean you need to disclose a lot of information. The actual disclosure obligations in Canada are quite minimal as compared to what is required with a CPSC. But you do need to report, and it does buy you some goodwill because Rachel will talk about what can happen if they feel that you are underreporting and that you have failed to meet your obligations, and how Health Canada might approach you as a company in terms of your relationship. Another thing is product media attention. If there's been significant media attention around a product or an issue with a product, that can raise some scrutiny by Health Canada in terms of looking into your product and having some concerns about whether or not you're meeting your reporting obligations. And so, it's really important that you have a process in place for consumer reports and how they're escalated to ensure you're keeping Canada in mind in terms of your reporting. As Rachel said, very little reports, I think it's less than 10%, actually trigger any corrective action. Most reports are requested because Health Canada wants to see the pattern of misuse that might exist with certain products, or if there are certain issues that arise in how people are using a product. The most common scenario that Health Canada uses when explaining this is that, a couple of years ago, a lot of people were using lawnmowers to hedge trims. I mean, to trim hedges. And now in Canada, there are warnings about how you use lawnmowers, because there were so many consumers who were injured in that way. We all would think that that's slightly ridiculous, but in some form or manner, they saw a pattern of misuse by Canadian consumers. And they've also implemented as part of that, a social media campaign on educating consumers on proper use of products and risks associated with certain categories of products. In terms of what guidance is required, what investigation, you do have time to investigate, but the expectation is that you're going to notify early and that you're going to give them the information that you have and then request an extension before filing a further report. In Canada, they do have teeth. Health Canada does have the ability to levy administrative penalties and fines under the CCPSA. They rarely actually exercise the opportunities that they have against companies. And in fact, they only typically use them where there has been a flagrant and intentional disregard of their obligations under the CCPSA. For example, when someone continues to sell a product that is recalled when they've been notified. Most occasions, Health Canada takes a collaborative approach. So it's okay to be a little bit late, but if you have notification that someone's been injured and it's alleged to have occurred with your product, then you should take the time to start looking at filing a report.
So when do you have to report? Technically, you have to report within 2 days of becoming aware. You have to report to Health Canada and to the entity from whom you received the product. So you may not be the manufacturer if you're having it manufactured for you under your name, that kind of thing. That 2 days is a tight timeline. We have not found that Health Canada is particularly fussed when reports come in after the 2 days, as long as it's not a consistent pattern from a company and we're not talking about months and months of delay. A few days, they're not going to notice. And I've not personally had any fuss from Health Canada about that. Now, all levels have to report, regardless of who's already reported. Health Canada really expects a closing of the loop environment where manufacturer, importer, seller are all reporting. So even if you know that the retailer has already reported and they're planning on taking carriage of this recall, you as a manufacturer still have a duty to report. They are relying on multiple reports to ensure that all the incidents are being captured. And I see in the questions, does Health Canada advise manufacturers of incident reports that they receive from consumers? They do. And then they expect that you are going to close the loop on that. So they will get a report from a consumer, they'll send it off to you, and they'll ask you to do your own investigation and to report on your own as well. That can be a tricky situation because a lot of the time, the consumer doesn't want to talk to you, and you can't really do the investigation as you'd like to. But there is an expectation that you will report in that scenario. And I'll turn it back to Lindsay.
Okay, and so the 10-day requirement, when we say 10-day report, that means 10 days from the initial, like when you became aware. So it's really 8 days following the 2-day report that this full report, which is akin to your full report, becomes due. And the full report really is just, are corrective measures required relative to the incident that's been reported, why or why not? And they look for the company's consideration of, did you review the product? Do you see that there had been a modification or altercation? Was there, do you have other incidents of a similar nature? And why is this something that shouldn't attract a corrective action, whether it's better instructions or a recall if there's been significant injury or harm that's been occurred? Most 10-day reports are filed much later because the general practice is to file or seek an extension from Health Canada following the preliminary report or the 14.2 report and ask for an extension because it typically takes you much more time to get the product back, to be able to have an engineer review the product and see if there's any issue or functionality that you assess in terms of how the product is. And, note if there's been any issues, also for you to review other incidents that you might have. A lot of the time we want to align the 10-day report with the full report in the US and ensure that the language is aligned in terms of the disclosure that is given. The rationale being Health Canada does talk to CPSC, even though the Act technically requires a written agreement from them to allow them to disclose specific details of a case, they still do it absent that written agreement. They don't seem to be bothered or fussed that they are not in compliance with the Act or their obligations, but you do really want to be careful to ensure that the number of incidents that you're disclosing to both regulators is the same. And a lot of the time, you're going to need to wait to get the details for, generally distribution and the number of incidents reported is often greater in the US. And to do your due diligence, it's fine to ask for an extension, but make sure you are writing to Health Canada and seeking that extension and just saying that you're doing it to do your investigation. They're generally very amenable and they don't take issue. And in terms of considerations, if, both Rachel and I helped set up an industry group meeting with Health Canada, and, we're happy to do that if you'd like. But, if they see reports from your competitors on a similar product and the issues that they've experienced with that, and you have not filed any reports associated with that product, Health Canada will assume that you are underreporting and that you're not disclosing your actual knowledge or awareness of incidents that have occurred. If your first report, often we are looped in a little bit later because you've assessed whether there's a substantial hazard associated with the product and you've decided that you're going to take corrective action in the US, and counsel asks, well, is the product in Canada? And you say yes. And then that's when you loop in Canada. So a lot of the time you've already made a decision before you're notifying Health Canada of the intention to take corrective action. You can just skip the queue and complete the entire form, including Section 7, so that you accelerate to go to the recall questionnaire, because that's typically what would follow the full report if you're taking corrective action. Um, you know, a lot of the time we're waiting on the CPSC, and the Health Canada timelines as it relates to recalls is prescribed by law. They need to post and circulate and obtain the information within a certain set number of days. And so they'll ask you for the recall questionnaire and your comments on the recall poster well before you've even worked out a corrective action plan with the CPSC. That's not abnormal. Just ask them for an extension and note that you're waiting for approval with the CPSC and that you're not in a position to communicate yet. That typically works, and they just diarize it for a later date. It's not a problem to ask for an extension. And Rachel, over to you on evaluated, not an incident.
So you can report as evaluated as not an incident. This would be a situation where it feels like you probably need to report to Health Canada, but you're so certain that this is not a real problem. This is like where you know that the product has been used improperly, so serious misuse, or where it's been it's a product that's inherently got some level of danger and like a knife cut somebody. These are, there's this option to report as evaluated, not an incident. Often there's no response from Health Canada when you do this. We think that it does engender some goodwill with Health Canada, particularly because they're looking for over-reporting, and it's kind of an easy way to do that. But obviously there is, some sort of consideration as to whether or not that is it's an appropriate circumstance to do it. You may want to do it where you're reporting out of an abundance of caution because of specific consumer reports, or maybe because you are reporting to the CPSC or some other global entity. So it is an option that's available. Should you use just your Section 15 CPSC report and just send that over to Health Canada? You could. The content is usually the same, but we don't recommend it. And this is because of the confidentiality protections that may not be met if you're reporting this way. There are specific boxes that you can tick in the Canadian form that asks whether or not the information can be provided to other Canadian governmental agencies. And you want to make sure that that language is in there. With that being said, anything you submit to the government is going to be the government's now. And so it is possible that it's going to fall within an Access to Information Act request. We want to do as much as we possibly can to protect that information and to at least get a heads up from the governmental agency when there's been a request for that information, so that we at least have the opportunity to opine and to try and limit some of what is given to the requester.
Rachel, can I just pop in here?
Yep.
Yep.
Clearly, any document, any 15B report you file with a CPSC is discoverable in a product liability case in your possession. Now, they may not be able to get it from the CPSC, and then they have to go through the Freedom of Information Act, but it's in your possession. Similarly, anything you're sending to Health Canada is in your possession and would be discoverable. So whether you send Health Canada your CPSC full report or not, it may or may not matter in the product liability context as it relates to discovery.
In Canada, though,
Yeah.
in Canada, though, there is some decision saying that if the form of information that has been filed with Health Canada is not compulsory, then it's not protected. And so this is more in the sense of there's been a corrective action by a company. They undertook a corrective action or recall when they identified an issue. And a entrepreneurial plaintiff's counsel wants the file from Health Canada to get specifics or details or information relative to the filings. If it was a 15B report, there is some case law that would somewhat hamstring your ability to argue that the form of that report or the information in that report was compulsory because it was provided in a manner that was not protected in Canada. And that's simply what we're saying. If you want to protect it by an access to information request, it's best that you use the forms provided by Health Canada.
Okay.
And I see a question, what's the benefit of the E&I? In my experience, we recommend an E&I where we think Health Canada would probably call it an incident, but we think it's arguably not. And the benefit is if you do it as an E&I, you don't have to do a follow-up report that then says, you know, whether or not you think that there's a need for corrective action. You can just do your one report, and there's usually not much follow-up from it. So I would say that's sort of the benefit. Lindsay, do you have any other?
Yeah, I mean, I would agree. I mean, I also use them where I'm closing the loop where a consumer report has been filed and we can see clear misuse based on the
Right.
instructions and warnings on the product itself. And we would say that the product was clearly misused and ignored, you know, the consumer ignored the express warnings, which are X, Y, and Z. A lot of the time it's like they were using an extension cord where it was prohibited by the use of the product. And there was an alleged, you know, shock like issue with in terms of the electrical components of it. Or it's, you know, it's a mold issue. It's not been identified as a safety issue, but you're reporting to other regulators because you're compelled to, and you don't have to say whether or not, and I'm not talking about mold in the context of food. I'm saying maybe on a product, you would say that it's not really, there's no injury that occurred, there's no potential for injury, but out of abundance of caution, you're doing it in part to buy goodwill to show that you're actually reporting and applying some nuance. And you recognize that you've already reported to another regulator that may be in communication or have a memorandum of agreement with Health Canada in terms of disclosure.
So next slide. Just on timing issues, often you're going to have to file the Canadian 10-day report before you finalize with the CPSC. I mean, that almost always happens because if you are looking at corrective measures, the CPSC does take a much stronger role on ensuring that the documents are to their liking and that the plan is to their liking, whereas Health Canada does not take as much of a role. So you're going to have to report before anything is really finalized. What we'll typically do in that case is we will indicate in the corrective measures section that we're working with the CPSC. We're planning to implement the same program in Canada. And then that usually will buy a lot of time because they know how much longer it takes in the US, and they're happy to have the US do the legwork, honestly. We also would use this opportunity to let them know if we're working with another Canadian agency like the Electrical Safety Authority or the TSSA, which is the Technical Safety Standards Authority.
Association.
Yeah, Association. I got it.
Yeah.
Yeah.
And sometimes there's crossover between, so electrical products in Canada are both regulated by ESA and Health Canada. If it's a consumer product and a commercial product, Health Canada generally will be given deference to lead the charge and oversee the issue. Because the electrical safety authorities are all provincial and Health Canada has jurisdiction over all of the provinces, that's currently the guidance that we're receiving from those two agencies. And so certain products right now, there is a bit of a regulatory gap. Also, Health Canada has their view in terms of who should be overseeing these products, specifically golf carts and electrical bikes. So electrical bikes that go less than 32 kilometers per hour are from Transport Canada's perspective, in Health Canada's jurisdiction, because they changed the regulations such that they do not oversee any of the e-bikes that go less than 32 kilometers per hour. Similarly, golf carts are in a bit of a vacuum right now in terms of how they are defined and overseen. However, Health Canada has taken the view that Transport Canada actually has authority over these products and that they are the authority that should be overseeing them in most cases. I mean, in a meeting that we had with Health Canada. However, Transport Canada has also indicated in writing that they are not overseeing these products, and if they fit within this little gap, they are not intending to require distribution akin to the Motor Vehicle Safety Act. That being said, the best practice with these products that are in a bit of a gap or a vacuum is to report anyways. Generally, in our view, if you report with Transport Canada, they'll tell you to go to Health Canada. You report with Health Canada, they'll tell you to go to Transport Canada. But given that there's this vacuum, you still want to follow best practices as it relates to these products that are unregulated, as it relates to an oversight in Canada for corrective actions. If you are putting out a corrective action plan for products that don't seem to fall within anybody's proper authority. In Canada, and most clients are pretty reticent, or they used to be, about how they would pull out or push out recalls. But recent case law has actually confirmed that a well-designed recall is actually preferable to a class action, and it's not a precursor. If you do it right, there's some recent cases that I put up there: airbags, heat recovery ventilators, cell phones, and flushable wipes. All of those companies, the Burr and Tecumseh decision is the only one that's not a class action. It's an individual product liability claim. But in that case, the court said that the recall was well done and they did proper notification, and therefore there was no failure to warn claim in the product liability context. In the other cases, the flushable wipes, the airbags, and the cell phones, each of those entities staved off a class action and managed to convince the court that it wasn't appropriate to proceed as a class action because they had implemented a well-done recall. And I've put a few considerations that the courts looked at in all of those cases. It should be done quickly, take an expansive report approach. You know, you should focus on repair, refund, or replacement, and the process should be user-friendly. There should be a robust notification process, focus on reach and uptake of the consumer. And we all know how difficult it is to get that. But as long as you can show that we're using social media, website, and you're trying to reach your consumers, the courts will take that into account in Canada or at least in Ontario, I should say, not in Quebec, but in Ontario as it relates to potential class actions.
Can I just add something? In the US, there have been similar lawsuits filed against manufacturers for doing, or retailers for doing, a recall, which left the consumer arguably with some economic loss. And we've had a lot with automobiles. The most recent ones in the US are against Shimano in a crankshaft for a bicycle, and also a product sold by Best Buy. So when you're designing your recalls, you want to consider both US and Canadian to try to determine whether you can provide an adequate enough recall or corrective action so that you're not going to wind up then with additional class action lawsuits filed against you.
Right. And if you're doing something for your US consumers, you should be doing the same or similar for the Canadian consumers. And because if the remedies are different and you're being much kinder to your US consumers, that will be something that the courts look at in assessing whether it was a preferable procedure. And with that, Rachel's going to talk a little bit about access to information before we go on to audits.
So just other reporting considerations. Health Canada wants to hear from you early and often. As Lindsay mentioned, we set up an industry meeting with Health Canada, brought up a bunch of clients from the US, and they said in that meeting that because you're here, you're not the companies we're worried about. So they really do take that into consideration. We talked a little bit about confidentiality already. That incident reports and attachments are not exempt from disclosure under the Access to Information Act. Current complaints are underreporting because we have such a low population relative to the US and therefore way less incidents. It makes it difficult to identify trends. So they do expect overreporting. That's also why they're looking for that closing the loop, getting retailers to report as well. They complain about timing requirements not met, but have never really done anything about that, as far as we're aware. And they complain about the interpretation of whether an event indicates an unreasonable hazard by industry. The complaint is that that consideration has been too technical, engineer focused, rather than from the perspective of a consumer.
So what happens when you submit a report? You'll be given a case number. There's a triage report or system that Health Canada applies. As I said, if it's a vulnerable person that was involved, expect that you'll hear back from them within probably 24 to 48 hours, requesting further information. There is a priority system in place. Silence is golden. Unlike the US, you do not get a closure letter. There is no, we're closing our file. In rare circumstances, for example, I had a client whose product was withdrawn in the EU, and that caused the client, Health Canada, to reach out to the client, who then engaged us. We filed, we told Health Canada that recall had nothing to do with Canada. It's relating to the toy directive, and that is no force or application in Canada. Here's a test confirming that the product complies in Canada. And they said, okay, we're not taking any enforcement action. That is the closest you will get to a closure letter from Health Canada. Expect to hear from them quickly if it's a child, especially, or if it's a death. And they may actually look to repost recalls if they feel that they're getting a number of incidents after a recall took place, but consumers are continuing to get injured. In those circumstances, Health Canada would typically ask the company to repost. And it doesn't have to be a number of incidents. If it's a death, they probably ask you to repost, even if it's just one. Health Canada is less likely to intervene and question the company's judgment about whether or not corrective action is necessary if they're known to have a robust risk assessment program and field data evaluation program, which brings us to Rachel's story of what not to do as a company and the consequences of what can happen.
So if you are on Health Canada's radar as a non-compliant company, if you are not reporting in the way that they want you to, if they are worried about your timing, you're reporting a year later about an incident that was clearly reportable. If there's a trend, they can order a compliance inspection. And while it's not necessarily a kiss of death to the company by any means, it is a big pain for everyone who works there because it takes a lot of time away from the employees. They're focused on CCPSA related internal roles, responsibilities, and training, meaning what kind of training is going into the consumer hotline, what sort of processes and record keeping is related, is being done relating to purchasing so that you can trace products if there is a recall, what process is in place to ensure regulatory compliance, how are consumer complaints handled, how are they tracked, how are we learning about trends, and the process is cooperative. It's supposed to be, as it says here, a no jeopardy situation. But again, it is a lot of work. They will send questions in advance. There's documents that are requested in advance. You need to have all of the relevant people and records on site. They want to do it on site. They won't do it at the law firm. They want to be on site and look at the documents. They want to talk to people that you may not have prepared. They want to look in warehouses. And they're going, I've seen them ask just people in the at the help desk ask questions about the type of training that they received, ask them to show them the training manual that they used. So it's important, as we put here in all caps, prepare like you would for a deposition. But it's not just one person, it's everyone, because anybody could be asked a question when they show up that day. So it is a lot of work, and can lead to even greater scrutiny if you kind of fail that inspection.
And with that, we can let questions open up.
So we've got 4 that we haven't answered yet.
I can't see them, Rach.
So. Oh, okay. So I will read them, and then all right. So the most recent one, where a recall is related to a battery issue, battery could injure or damage property. Is there any discussion between Health Canada and Transport Canada where the remedy may contravene TDG regulations?
Generally, the regulators do talk. When we were in our meeting with Health Canada, they said that they have regular updates and meetings with Transport Canada. Now, whether they actually look at logistics, I expect that you'd actually have to raise that as a concern as opposed to them considering it in advance, from my experience with them. On battery issues, also, you have to consider how you're directing consumers. In Canada, there's the Call to Recycle program here, and they typically get very aggressive, sorry, with companies because they have contracts with the government in terms of disposal of battery issues. Often it's easier to deal with disposal of dangerous or what constitutes dangerous goods in country as opposed to trying to ship them back. And you'll have to consider, because it's municipal in Canada, when we talk about disposal obligations, it's not at the federal level. So it requires a lot more logistics, knowing where you're selling in the country.
Okay. Are there any reporting requirements for products sold strictly through commercial channels? So we talked about that a little already, in that if it's a product that could make its way into the hands of a consumer, be used in a consumer home, even if it's installed by a professional, it could still be required to be reported up through the CCPSA to Health Canada. It depends.
And then there's the ESA.
Yeah, and that, exactly. So, but if it's not CCPSA, there are other reporting agencies that you may have to report to, depending on the type of product. Like as Lindsay said, ESA, TSSA. It just depends on the product.
And in terms of electrical, so anything that plugs into the grid, whether direct or indirect, if it's not a consumer product and it's a commercial product, then you have reporting obligations that exist in each of the provinces as it relates to the electrical safety authorities. Now, generally, you can report to one province and ask that they take jurisdiction over it. But an ESA in Ontario tends to take the lead a lot of the time in Canada. But they also have, they're a very difficult agency sometimes to deal with because their engineering staff are very limited and don't necessarily have wide knowledge. So sometimes you'll have to bring in external folks to educate them.
Do we have a template report to send? Yes, we can send a link after this to the report, the blank report that's online and available.
Yeah, we'll be posting reference material or links to the to the website so you can find things.
Are EN standards considered in risk assessment? Lindsay, you want to take this one?
Yes, and if you've been asked for a risk assessment, look, as I said, Health Canada is happy to look to um, other organizations or standard bodies, as I said, ASTM, ISO, EN. And in fact, for their general prohibitions list, they do actually cite EN standards for a number of products. So that is a consideration, and that's completely fine. Now, for certain products, there may not be a standard for you to look to. The expectation is that you're going to look to a similar standard when doing your risk assessment or category of products that may fall closest to your product.
Well, and in the US, we do risk assessment, usually pre-sale, but there's not a formal post-sale risk assessment process, and the CPSC almost doesn't even like to consider that. Obviously, in the EU, as if you've attended the earlier webinars, the EU has a fairly detailed post-sale risk assessment process, which is pretty similar to pre-sale risk assessment. So it would be a good idea to do a similar risk assessment for EU, US, and Canada, although there are differences, of course, in the way consumers use products or how they view risk. So it's hard to say that it would be exactly the same country to country.
Okay. Does Health Canada provide status updates to those persons or entities who file incident reports with them? I assume that means like consumers, and sometimes, but the consumer report is intended to be somewhat one-sided. They report, the information goes to Health Canada. Health Canada brings it to the manufacturers, and then it's in Health Canada's hands.
Oh, and but although I mean, in a recent experience with the consumer that we had, um, if you're claiming confidentiality, they're not going to share any of your information with the consumer other than to say that the company filed a report and
Yeah.
that Health Canada is content with it. Um, the consumer may be, difficult. We all have had difficult consumers that we've dealt with if we've ever been in the service industry. Um, and so, in some cases, we've had consumers who keep going back. And then our recommendation is you still have to then respond to Health Canada and say, based on the information we have, there's nothing further to report if there isn't any new information that you're in possession of. And then, happily in that case, Health Canada recognized that the consumer was maybe not necessarily being rational when they were bringing forward their complaints.
What if there's a theoretical compliance on paper of the product, but there's a problem with the individual product purchased? So assuming that means like we've got a one-off problem product. I know this is an anonymous attendee. I think that's what you're probably asking. I mean, it's still definitely reportable, but if the company can do its investigation and conclude that, we have this one product that was a problem, and we've searched all of our records, it's not a trend. We can usually make the pitch to close it right there and that no corrective action is needed.
Oh, and I see the next question. I took off the share so I could actually see the question.
Oh, there you
So
go.
come into effect. So most legislation in Canada comes into effect when it's published in the Gazette, which is the way that our legislation is circulated to the lawyers, or it may be tied to a specific date when it receives assent by the Governor General. Again, that is typically published in the Gazette, so you do get notification. Typically, Health Canada, for new regulations, as they've done recently with a number of regs, issues an intention to amend or revise a specific piece of regulation, and they'll seek industry comments. The expectation is that they'll either get comments from specific companies or industry groups. Recently, there was an amendment put out to the flammability issues in terms of tents. Health Canada tried to adopt what many see as a problematic standard in terms of how they're applying it and the tests that they're going to use. And I know that industry comments were pretty significant, and that has delayed implementation from Health Canada as they consider those. So the expectation is you will be consulted if there's a change to come in your specific industry relative to the regs that apply. And do take the time to provide feedback if you notice a problem, because if you don't speak up, then that's ultimately going to be the legislation that's implemented by Health Canada, problems and all.
How aggressive is Health Canada with e-bikes? Zero aggressive.
Zero.
Health Canada has taken the position that they don't fall under Health Canada's regime, and Transport Canada has done the same. So right now, e-bikes are unregulated in Canada, and both agencies are saying not us.
Yeah, both agencies are pointing to each other quite clearly, and both have said so in meetings that it's the other person that's handling it.
Would you comment? There was an earlier question which I answered separately on foreseeable misuse. And one of your earlier slides said you needed to report for foreseeable use and misuse. What about unforeseeable? You've never had an accident like that before. I guess because in the product liability sense, we can foresee anything, of course, as the plaintiffs tell us. But for Health Canada reporting purposes, if you've never had an accident before, how far do you have to go to identify unforeseeable misuse? And if you have that first accident, then does that make it reportable?
So, I mean, I think that is where we get into that. Do we report as an ENI and evaluate it as not an incident, or do we report it as an incident and say, but we're closing it up because we know that this was misuse? And I think it's one of those judgment call things that I think Lindsay and I kind of go with our gut on, and call each other up and say, this is what I'm thinking about doing. Do you agree? It's just one of it falls into a bit of a gap, but it's probably reportable one way or another, whether it's as an incident that you then close the loop on, or evaluate it as not an incident.
Especially if it's an injury or property damage. Yeah. I mean, and if it's from a plaintiff's lawyer and they say, oh, you should have known, which they often do, as soon as it says injury and there's a plaintiff's lawyer, it doesn't matter. It's reportable, because, they're saying that they sustained an injury and they've retained counsel. So often in those cases, when you note to Health Canada, it's just a demand letter that you got from a plaintiff. You have no further information. They totally understand, and it's silence because they understand you're reporting, you're meeting your obligation, and that you have no information beyond the letter itself. And that's often what we provide as context.
Okay.
Do we need to send a recall campaign report to Health Canada if we already sent it to Transport Canada? No, if something falls under the Transport Canada regime, you don't need to report to Health Canada.
Okay, I want to ask another question, something we talked about earlier. That is, you said earlier that if you report to the CPSC and you've sold in Canada, you should be reporting to Health Canada. That's pretty easy. What about the other way around? Let's say, because you've got definitions of consumer products, they might be different from country to country. A definition of an incident, different thresholds for reporting. And you said that that Health Canada expects more reporting probably than the CPSC does. Can you envision a situation where it'd be okay to report to Health Canada and not the CPSC?
Yeah, I mean that happens all the time on the reporting side. Now, if you were going to move through to corrective action, then you definitely want to make sure you're doing the same thing on both sides of the border. But on the reporting side, it happens all the time that you would report in Canada and not in the US.
Okay. Now, and I would say from my side, if you're going to do a corrective action in the US, you better have reported to the CPSC because you don't want to have to do it again. And you don't want to have to start explaining that you're doing. So if you're not going to, if you report to Health Canada and say no corrective action is necessary and they agree, then arguably then you get to decide whether you report to the CPSC and argue the same thing and use Health Canada's confirmation that no corrective action is necessary. So anyway, the point is just that those of you listening, you need to consider both countries and how you're going to address each of them separately, particularly when there's a difference in reporting levels or even corrective actions required.
Yeah, no, I mean, look, Ken, the issue is our trigger is so low here in Canada. I know the current atmosphere in terms of fines in the US with CPSC and late reporting consequences are quite significant. You don't have the same here, but you can buy a lot of goodwill with Health Canada and avoid, they are getting more active in terms of inspections and audits. Their first step is usually to educate, but I have known Health Canada to see they do troll recalls in other countries, and they will, if they think there's a presence in Canada, write and ask why it's not being recalled, why hasn't it been reported? We want you to do it right away. And you don't want to be in the position of a company that failed to report a corrective action when you knew that the product was being sold through e-commerce on both sides of the border.
Okay, well, we've hit the hour. Thank you very much. That was a terrific job. Great slides. We'll post the slides, a link to the recording, other material for you. And thank you, Rachel. Thank you, Lindsay. Thank you, Sedgwick Brand Protection, for sponsoring our program. And thank you all for attending today. We appreciate your support and hope you continue to watch our webinars as we go through the year. Thank you all very much.
Thank you
Thank
so
you.
much.